Welcome to Special Immigrant Juvenile Status, SIJS, and SIJS-based Adjustment of Status 101. My name is Dalia Castillo-Granados, and I'm the Director of the Children's Immigration Law Academy, or CILA. This 101 webinar is being recorded on March 28, 2023. It is one of a series of webinars we have available for advocates who are new to the field of children's immigration law. We will cover the requirements for special immigrant juvenile status and adjustment of status based on SIJS classification. Please note that immigration law changes rapidly. It is important to stay up to date with case law, policy updates, and any procedural changes. We're going to go over a little bit about CILA. We're also going to go over an overview of special immigrant juvenile status and SIJS numerical limitations. We'll discuss SIJS deferred action and SIJS-based adjustment of status, and then we'll let you know how to stay in touch with CILA. The Children's Immigration Law Academy, or CILA, is a project of the American Bar Association Commission on Immigration. We are a legal resource center, and we try to build the capacity of organizations that are working on unaccompanied children's cases throughout the U.S. We do this because we believe that every child should have representation in immigration court. CILA services have recently expanded to reach a national audience. We are based in Houston, Texas, and still provide some Texas-specific resources and trainings, but we also have expanded to provide services to the national network of legal service providers serving unaccompanied children. We provide technical assistance, so an attorney or a legal staff can contact us with case-specific questions. We also provide regular trainings, including webinars and more in-depth trainings as well. We have a lot of resources available on our website, CILacademy.org, and we also host several working groups, some to a national audience, others are still specific to Texas. We also have a pro bono program to support pro bono coordinators and pro bono programs at the legal service organizations, including through a platform called Pro Bono Matters for Children Facing Deportation, which aims to match pro bono attorneys with pro bono case opportunities. We offer free resources on our website, including this detailed pro bono guide that goes through how to work with children and youth in their immigration cases. We also record all of our webinars, and they are available on our website. SIJS is one form of humanitarian-based immigration relief that is available to children. Other forms of relief, such as asylum, U non-immigrant status, T non-immigrant status, and VAWA, are covered in other 101 webinars that are part of this series. Now we'll start with an overview of special immigrant juvenile status. What is special immigrant juvenile status? It's a form of humanitarian-based immigration relief for non-citizen children that are here in the U.S. and have suffered parental mistreatment. Who qualifies for special immigrant juvenile status? It could be children in our state's foster care system, but it could also be children that are in the care of the Office of Refugee Resettlement because they've been determined to be unaccompanied. It could also be children living in our communities, so a child living with a non-parent caretaker, or even a child that's living with one parent if the other parent abused, abandoned, or neglected. Once a child has special immigrant juvenile status, then they can seek lawful permanent residence or their green card once it is their turn in the queue. There's only a certain amount of immigrant visas available each year, and so a child must wait for their immigrant visa to become available before they're able to seek their green card. Once a child has a green card, they're on the pathway to become citizens. So they can apply for citizenship after a certain period of time and once they meet all eligibility requirements. SIJS was created in 1990 to address children in our state's foster care system. So the statute at that time required that a child be eligible for long-term foster care. There was an update in the law in 1998 that added the requirement that a child had to be eligible for long-term foster care because of abuse, neglect, or abandonment. The statute also added something called the consent function. The consent function is the immigration agency trying to assess whether or not a request for special immigrant juvenile status is bona fide. In other words, that it is to seek relief from parental mistreatment and not just for an immigration benefit. In 2008, the law was expanded in the Trafficking Victims Protection Reauthorization Act, or TVPRA. It eliminated the need for a child to show that they were eligible for long-term foster care, and instead, a child has to show that they are unable to reunify with one or both of their parents because of abuse, neglect, or abandonment, or a similar basis under state law. In April of last year, new regulations were finally adopted. The regulations that we were going by were actually last promulgated in 1993, so did not keep up with all the statutory changes that were made over the years. There was a proposed rule that was released in 2011, but that one was never finalized, and so the proposed rule was released again in 2019, and then it was finally published or promulgated last year. So 8 CFR 204.11, where most of the regulations are, relates to SIJS petitions. 8 CFR 205.1 references revocation of SIJS, which is actually moved to, the revocation provisions have moved to 204.11. And then 8 CFR 245.1 relates to SIJS-based adjustment of status. So here we'll go over the statute and also the regulations. The statute can be found at INA 101A27J or 8 USC 1101A27J. The statute defines who is going to qualify as a special immigrant juvenile. And you can see here that it's an immigrant that's present in the US. It's under the jurisdiction of a juvenile court that makes specific determinations about parental reunification and best interest. The statute also includes the consent requirement, which I touched on a minute ago, where the immigration agency assesses whether or not the request is bona fide. And also importantly, the statute makes clear that a parent cannot get an immigration benefit through a child if they receive special immigrant juvenile status. A parent can get immigration relief independently, but not through their relationship with their child, even if it's a non-offending parent. The regulations, as I mentioned, became effective as of April 7th of 2022. It has a lot of definitions. So for example, juvenile court is mentioned in the statute, and the regulation defines what that means. And it's a court located in the US that has jurisdiction to make these judicial determinations that we touched on. It also goes over the eligibility requirements and the process for seeking special immigrant juvenile status, which we'll go over in a minute. And it also has those automatic revocation provisions, and we'll go over those revocation provisions in a minute. Also, importantly, another great resource is the USCIS Policy Manual on Special Immigrant Juvenile Status, which has even more detailed information than the regulations and gives some insight into how USCIS is adjudicating these petitions. So the eligibility requirements are that a child has to be physically present in the US, and that's at the time of filing and through adjudication of the SIJS petition. A child has to remain unmarried, so has to be unmarried at the time they file the petition and then remain unmarried through the adjudication of the SIJS petition. This is a really important change that came about in the new regulations. Previously, a child had to remain unmarried through adjudication of their green card or through adjustment of status. So that is no longer the case, because it's taking many years between getting special immigrant juvenile status and then finally receiving a green card. This is a really important change. So the child only has to remain unmarried through adjudication of the SIJS petition. Once they have SIJ status, then they can get married and still be eligible for their green card. The child has to be under 21 on the date of filing the SIJS petition. They have to have a valid juvenile court order with specific determinations, and they also have to warrant consent. So USCIS is going to verify that the request is bona fide and not just for an immigration benefit. There are 3 key phases for an SIJS case. First, you have to obtain a state court order. Then once you have that state court order that meets the requirements for special immigrant juvenile status, then you can petition for SIJS at USCIS using a form called an I-360. And then once you have special immigrant juvenile status and an immigrant visa number is available, then you can apply for lawful permanent residence or your green card using a form I-485. So although we would prefer that one step follow the next, the child may be involved in simultaneous proceedings. So the child may need to attend removal proceedings if a notice to appear has been filed with the immigration court. The child and the attorney may need to attend several master calendar hearings where they keep the judge informed about the progress of the case. At the same time, state court proceedings may start with the relevant state court petition being filed. And once that state court order is obtained, the child will need to file the SIJS petition on Form I-360 with USCIS. Now, if the child is not in removal proceedings and has a current priority date, which is not the case now for any child, but can be perhaps in the future, then the application to adjust status on Form I-45 can be filed simultaneously. But if the child's in removal proceedings, then they need to wait until the I-360 is approved before moving forward to adjust their status. And the child could seek adjustment of status before the immigration court or before USCIS if their removal proceedings are terminated or dismissed. So there are 5 requirements for that state court order to qualify for special immigrant juvenile status. First of all, the order has to be valid. The order has to make a judicial determination about custody or dependency. There has to be a judicial determination about parental reunification. There must be a judicial determination about best interest. And finally, that order has to warrant consent. So what does it mean for an order to be valid? Well, first of all, it has to be issued under state law. So one of the important things to remember here is that that includes whether a court qualifies as a juvenile court. And again, this is defined in the regulations, and it's a court that can make judicial determinations about custody and care and or dependency of a child. And a child is going to be defined under state law. So, whether it's child or any other equivalent term, it has to be under state law. And so, for example, if a child is wanting to get into state court to make these determinations, then they have to be able to be under the jurisdiction of the court. Some states allow for extended jurisdiction after a child turns 18, so between 18 and 21, such as California or New York. And other states, a child will only be able to go into state court if they're under 18. So that is important to remember. And then secondly, the court has to have continuing jurisdiction over the child until they age out of the court's jurisdiction. So again, Arguments, it's important to make arguments under state law, not the immigration statute or the regulations, and important to not cite to any immigration statute or regulation in the state court pleadings, because that will be a red flag for USCIS. And then in order to be valid, the court, the petitioner, the child has to remain under the jurisdiction of the juvenile court. If an order is vacated or terminated because there was evidence or subsequent or something else came about that ended up in the subsequent reunification of the child with their parent, then USCIS would consider the child to no longer be under the jurisdiction of the court. But there are some really important exceptions to this rule. If the child was adopted or placed in a permanent guardianship or some other child welfare permanency goal was reached, then that is one of the enumerated exceptions. And then secondly, if the order was terminated based on age, then that is another important exception. In fact, even if the court no longer has jurisdiction over the child because they have aged out, they can still at that time petition for special immigrant juvenile status as long as they're under 21. Another important thing to keep in mind is generally relocation does not mean that you need to obtain a new order. USCIS understands that the court would maintain continuing jurisdiction over the child. So there are 3 necessary judicial determinations that need to be made in the state court order. USCIS used to refer to these as findings, but now is referring to them as judicial determinations. So the first is that the child, there be a judicial determination regarding custody or dependency. The second is on parental reunification, and the third is on best interest. So going over the first judicial determination here, the child, there has to be a judicial determination either as to custody or dependency. It's either or, it does not have to be both. And so for custody, that generally would involve legal and physical custody, and it could, include different types of custody. So it could be a guardianship. In Texas, it could be a conservatorship, or it could even be an adoption. And custody can go to one parent if reunification is not viable with the other parent due to abuse, abandonment, or neglect. That would still qualify for special immigrant juvenile status. If the court finds that the child is dependent, then this should be because there needed to be some intervention by the state court to assess care or custody of the child or assess child welfare services that the child needs. So, this could be in many different types of proceedings, such as cases of abuse, neglect, dependency, termination of parental rights. And as long as the court has intervened to provide relief from abuse, neglect, or abandonment, then that will be sufficient for USCIS. And again, important to remember, it's either or, so custody or dependency. The second judicial determination is about parental reunification. So I think it's important to think of these as 3 separate findings. So first of all, the child must have suffered abuse, neglect, and/or abandonment, or a similar basis under state law. It has to be by a parent. So, USCIS does want to see some sort of parentage determination in the state court order. If parentage cannot be assessed, for example, if one of the parents is unknown, then USCIS would like to see that the court determined that the parent is unknown. But otherwise, some sort of recognition from the state court that it was the parent that abused, abandoned, or neglected the child should be sufficient. And then this is what made reunification not possible, that the child suffered this abuse, neglect, and/or abandonment. The third judicial determination is on best interest. The statutory language is that it would not be in the child's best interest to return to their or their parents' home country or country of last habitual residence. And this may make the adjudicator, the judge, feel like they're making an immigration determination, assessing whether or not the child should be removed from the country, for example, and that is not the case at all. So here, the judge should be making an individualized assessment, considering the factors that it would normally take into account when making a best interest determination. So the court can look at things like who are the available caretakers here in the US versus in the home country, where would the child be safe, where can they have access to services, and determining that the best placement is here in the US should meet the requirement for this best interest determination. So the order also has to warrant DHS consent. So, two things that USCIS is looking at here. They're looking for a factual basis. So they want to have some individualized statements. So who was the child placed with and how was that determination made? What ground, abuse, abandonment, neglect applies to what parent, and why was that determination made? And then, what did the judge take into account when making that best interest determination? The state court order can include these factual basis, or it can just be part of the record. So it could be that an affidavit was submitted with the facts that were needed to make these determinations, or a transcript. There's a transcript where a witness testified as to these facts. Even a attorney's statement on what was considered by the court can be taken into account by USCIS. USCIS also wants to ensure that there was relief from parental abuse, neglect, abandonment, or similar basis under state law. So, wants to see what the court-ordered custodial placement was, or what the court-ordered dependency for the provision of child welfare services was. So they want to see some sort of protective remedial relief from the state court. And this really comes into play when you're looking at dependency. And so if there is a dependency determination, then the USCIS will want to ensure that there was some sort of protective remedial relief by the court, and not just that the determinations were made. So just to summarize, what are some tips for ensuring that the state court order meets the requirements for special immigrant juvenile status? One tip is to start with a template. So like in Texas, it would be a family court template that you can start with. In California, they use judicial forms. And so starting with a judicial form, if you're in California or state that provides forms, then once you file that petition in state court, then it's important to get started on the case. Many of these cases will deal with international service of process, which can be very time consuming. And so it's important to learn about and initiate that service of process as soon as possible. While that is going on, it's important to gather evidence to present to the judge about, why the child suffered abuse, neglect or abandonment, by what parent, and have something to present to the court in order to get those judicial determinations. It's also really important to prepare the client for state court. So prepare any witnesses that you have, or the child, if they're the ones that have to testify in state court, prepare them for what that will look like and what they need to tell the judge, what kind of information would be important for the judge to have in order to make the determinations. And also, before you head into state court with that proposed order or proposed form, it's important to review all available resources, the USCIS policy manual, or any resources by an organization that frequently does this work before obtaining that final court order after a hearing before the judge. So once you have that state court order that is valid, that warrants consent and has the 3 judicial determinations, then you petition USCIS for SIJS classification using a form in I-360. So you prepare this form and submit it to USCIS. We recommend that you submit it along with the cover letter, the certified copy of the state court order, and also proof of age. That is one of the requirements. It's part of the regulations. This can be done through a birth certificate, but if a birth certificate is not available, then you can use other means to prove age. USCIS will then send an I-360 receipt notice, usually from the National Benefit Center, which is the USCIS Service Center that is adjudicating these petitions nationwide. And the petition must be adjudicated within 180 days. That is a statute that was found in the TVPRA. Right now, USCIS is adjudicating most petitions within 180 days, but not all. But they are, trying to stay within that time frame as close as possible. USCIS may request some additional evidence through a request for evidence, or they can issue something called a notice of intent to deny if they believe that not all of the requirements were met. And the petitioner should respond within the deadline for those for that RFE or NOID. And then USCIS will issue a decision either granting or denying the petition. If it's a denial, then the decision can be appealed to the Administrative Appeals Office or straight to federal court. So we're going to discuss the SIJS numerical limitations and why it takes so long between getting special immigrant juvenile status and being able to obtain a green card. So we'll start with something called a priority date, which is going to be important to this conversation. This is the date of filing that the child filed the I-360 petition. So if you review the I-360 receipt notice, there is something called a priority date right there on the form. And then, and this is the date that USCIS received the petition. And it also marks where a child is in line in order to get their immigrant visa number. The Department of State publishes this visa bulletin every month. And so this is the visa bulletin from April 2023. Special immigrant juveniles are considered special immigrants under the 4th preference employment-based categories, which is allocated 7.1% of the 140,000 visas that are available per year. So a little under 10,000 visas per year. There are other special immigrants besides special immigrant juveniles. And so SIJs do have to share the available immigrant visa numbers with other classifications. There's also something called a 7% per country limit, and that is a cap that if reached limits the amount of visas that are going to be available. Previously, El Salvador, Honduras, and Guatemala were designated as having reached this per country limit, but the Department of State, they decided that they had been wrong in the way that they'd been making this assessment, and so it's no longer one of the countries here that is separated out to reach because they have reached this 7% per country limit. However, this does mean that as of April 2023, all of the categories are retrogressed, which means that the priority date moved back in many of these categories. And so now any child that has special immigrant juvenile status must meet the priority date of October 1st, 2018 or before in order to have an immigrant visa number available to get their green card. It's also important to note that you can't use the visa bulletin to sort of assess where a child is in line. You can say that, right now USCIS is adjudicating adjustment applications for a child that filed their I-360 petition before a certain date, but that is not going to tell you how long a child will have to wait before their own green card or immigrant visa number is available. The Cato Institute does publish current wait times, and they did last year publish wait times for the EB4 category. And so you can see it's several years for many of the children, including from Central American countries like El Salvador, Guatemala, and Honduras. And so that is important to remember. Because of this very long wait time, there has been a lot of advocacy on the SIJS backlog. The American Bar Association, where I worked, adopted a policy resolution in February of 2021, urging Congress and the administration to enact laws and adopt policies to protect SIJS youth from removal and grant employment authorization while they wait for a visa to become available and they can seek their permanent resident status. The End SIJS Backlog was formed in early 2021, and the coalition is a national group of directly impacted youth and allied advocates that exist to educate Congress, relevant administrative agencies, and the public about the harmful effects of the visa caps and to advocate for the end of the SIJS backlog. One thing that the current administration did do to protect children who must wait a long time before they can get their green card through SIJS is that they are now granting deferred action for all SIJS youth that can't apply for adjustment of status because an immigrant visa is not immediately available. So this became effective as of May of last year, and USCIS does not have an application where a child can seek deferred action. Instead, USCIS will adjudicate the I-360 petition, and at that time, then assess whether or not they're going to grant deferred action, which is an act of prosecutorial discretion. So USCIS will weigh the positive and the negative factors in the child's case and determine whether or not to grant deferred action. SIJS eligibility is a strong positive factor, while any inadmissibility ground or potential inadmissibility ground, if there's pending criminal charges, will be a negative factor. Deferred action is granted for a period of up to 4 years. And if after 4 years an immigrant visa is still not available, then deferred action can be renewed at that time. One of the great benefits of deferred action is that a child may be eligible to get employment authorization or a work permit. The employment authorization is for the period of deferred action, so can be for up to 4 years. There is a fee waiver that's available for youth with SIJS deferred action, and it's using the same criteria as a fee waiver for SIJS-based adjustment of status, which means that you just need to include the SIJS approval notice, and that should be sufficient for the fee waiver. It's also important to note that usually those with deferred action have to show economic necessity in order to get employment authorization, and this is presumed for SIJS youth. So the form I-765 worksheet is not going to be required. And this even applies to young children who are unable to work, because USCIS does see the benefit of having an identity document, including for young children. So after, however long the child will have to wait, then they can, and an immigrant visa is available, then they can apply for lawful permanent residence using the I-485 form. So just to go over the statute and the regulations, you can find the SIJS-based adjustment of status statute at INA 245H or 8 USC 1255H. And this allows SIJS applicants to be deemed parole for purposes of 245A adjustment of status. And that's when a visa number is available, and also the applicant has to merit discretion, this discretionary grant of adjustment. The statute also lists the grounds of inadmissibility that are waived for SIJS applicants or waivable. There's also an SIJS specific waiver that's available for certain grounds of inadmissibility for humanitarian purposes, family unity, or when it is otherwise in the public interest. The regulations, which were updated as we spoke about in April of last year, does make clear that SIJS applicants are paroled for purposes of adjustment, regardless of the manner of entry. It also makes clear that applicants are not barred from adjustment based on unauthorized employment, and it also has a bit more details about that waiver of inadmissibility. One other thing to mention quickly is that there is a USCIS policy manual section on SIJS-based adjustment of status, which is also an important resource. So what is inadmissibility? So these are basically what would disqualify an applicant for adjustment to get their green card. So legal disqualifications. They can be based, there are health-related grounds of inadmissibility, criminal grounds, national security grounds, some grounds related to economic or employment. There are also immigration-related grounds of inadmissibility and other miscellaneous grounds. The grounds that are inapplicable to special immigrant juveniles, so they don't have to worry, these are automatically waived, are grounds such as being a public charge, being present without admission or parole, also misrepresentation, which includes a false claim to citizenship. So that is really important to remember because usually that is not a ground that is waivable for most applicants of adjustment of status, and other grounds of inadmissibility. Some grounds are waivable, so they do apply to special immigrant juveniles, but they can be waived with this SIJS specific waiver. So for example, some health-related grounds, or if a child or youth was convicted of prostitution or commercialized by vice, or if they fail to attend removal proceedings, then they can use an I-601 to get a waiver by using this generous standard of for humanitarian purposes, family unity, or when it is otherwise in the public interest. There are some grounds that are not waivable using this SIJS specific waiver. So they might be waivable under a different waiver provision, although, some of these are not waivable at all. But, most of these apply to convictions of certain crimes or any drug-related crimes, or if the Attorney General has a reason to believe that that the child or youth is a trafficker, then these are not going to be waivable under the SIJS specific waiver, and you can take a look at other waivers that might be available for these inadmissibility grounds. One thing to keep in mind, because we are discussing Children and youth is on juvenile delinquency. So, generally speaking, adjudications in juvenile proceedings are not going to be convictions for immigration purposes for inadmissibility grounds. But it's important to remember that it could trigger a conviction-based ground of inadmissibility if the youth was charged as an adult, which happens in Texas for youth that might be 16 or 17 years old. It can also trigger conduct-based grounds of inadmissibility. It could result in adverse discretionary decision because adjustment of status is discretionary, or it could trigger immigration enforcement. So a child, could be sent to immigration detention because of a juvenile delinquency. So even though juvenile delinquency records are generally confidential, USCIS is going to require that any juvenile delinquency adjudication be disclosed. So, it is important to submit these records, even if the records were expunged or sealed. It's important to either provide the documentation or provide information about why the records are unavailable. And then USCIS is going to evaluate the records or lack of records according to the nature and severity of the crime and determine whether or not, the child is eligible for adjustment of status or discretionary grant of adjustment. As I mentioned, their discretion does play a big role in adjustment of status, including SIJS-based adjustment of status. So, if the applicant meets all of the eligibility requirements, but there might be some negative factors in the case, then USCIS is going to weigh the negative factors versus any positive factors. So, positive factors could include things like rehabilitation, whether or not somebody is working, whether or not they're participate in community service, things like that. And hopefully those positive factors will then outweigh any negative factors. So adjustment of status happens differently based on the posture of the case. So if a child is not in removal proceedings, if the SIJS youth is not in removal proceedings, or they were considered an arriving alien, then they're going to adjust status before USCIS. If they are in removal proceedings, then they will need to adjust status before the immigration court unless the immigration proceedings are terminated or dismissed. So if you're applying affirmatively before USCIS, then you do submit that I-45 application along with these two other applications, the I-765, which is the application for employment authorization, and the I-912, which is the fee waiver, along with any necessary documents to USCIS. USCIS will then issue a receipt notice and also something called a biometrics notice, which will require the child to go to an application support center and take fingerprints, usually a picture, perhaps a signature, and depending on the age of the child, USCIS will run a background check on the applicant. Also around that time, the employment authorization document should also be adjudicated. USCIS can request further evidence using a request for evidence if they have not received all the evidence before issuing their decision. An interview, there can be an adjustment interview, but it is very rare. So we have not seen that. We have not seen interviews for SIJs, but that can be done at a local field office. And then USCIS will issue a decision either approving or denying the application. The decision can be further appealed. So if the applicant has to apply defensively or before the immigration court, then these are the steps. First of all, the applicant needs to follow the immigration court pre-order instructions, which will require that some steps be completed with USCIS. USCIS will issue that receipt notice and biometrics notice, but then the adjustment application and any accompanying document is going to be filed with the immigration court by whatever deadline set by the immigration judge. And then you should prepare for the merits hearing, which includes direct examination from the attorney and perhaps cross-examination by the ICE attorney. You must present your case at the merits hearing to have the judge adjudicate the adjustment application. And typically, if the case is not contested, then these are quick hearings. However, if there's an inadmissibility ground or some other, if there's a discretionary factor at play, then it could be a longer hearing. And then the immigration judge will issue a decision, and if granted, you must follow the immigration court post-order instructions, because it's USCIS that will issue the lawful permanent residence card. So, once a child is granted lawful permanent residence, this means that the child is able to work and live permanently in the United States. They can leave, they can travel abroad and return to the US under certain conditions. Of course, they can attend college, they can join the US Armed Forces. And once they're eligible, they can apply for US citizenship. They can also petition for certain relatives, but not their parents. They also, with rights come certain responsibilities. Lawful permanent residents must maintain a current address with USCIS. Like everybody else, they have to obey federal, state, and local laws and pay taxes. If it's a male, then they between the ages of 18 and 21, they have to register for selective service. And it's important to maintain lawful immigration status. So, for example, if they did commit a crime, then they could be put back into removal proceedings. So that's something that's really important for them to know. All right, that concludes Special Immigrant Juvenile Status and SIJS-based Adjustment of Status 101. We hope that you stay connected with CILA. Please feel free to reach out for technical assistance on a case. You can do so by going to our online form or calling or emailing someone at CILA. You can also join CILA's newsletter. It's a quarterly newsletter that we send to it's a monthly newsletter that we send to attorneys and legal staff that are interested in keeping up with children's immigration law. You can also always check out our website to view resources, to view our upcoming calendar of events as well. As I mentioned, our monthly newsletter, this is a QR code so that you can sign up for Champions for Immigrant Youth and stay up to date with news and policy changes and other important updates. I mentioned we also host a pro bono platform, and here 18 organizations across the country are able to post case opportunities and hopefully get a child matched with a pro bono attorney. So if you want to visit our platform, you can do so on the QR code on the left. We also have a pro bono newsletter, and that's a quarterly newsletter, and you can sign up for that newsletter by going to the QR code on your right. We are also on social media, so we hope that you'll follow us on LinkedIn, Twitter, Facebook, and YouTube. Thank you so much for your time. We really appreciate it and hope that you'll take a look at our other 101 webinars as well.